Okay, so this video is about how to fight back at a disciplinary hearing. So imagine this, you've been invited to a disciplinary hearing, you may have your manager, may have HR there. Do you think this is going to be a fair and open hearing? Well, I can tell you in my personal experience, it probably will not. The decision about what will happen to you has probably already been made, and HR advice will have been sought, investigations will have already been carried out, and evidence that is favourable to your employer will have been gathered. They will have already written a script and pretty much know what they're going to say. All the disciplinary meeting, from what I have experienced as a tribunal, is to gather evidence to support their case by either allowing you to incriminate yourself or allowing you to add evidence to their material that they already have. Now, there will be those in HR who'll scream that this is not the case, of course, it's always a fair process, this isn't the case, everything is open and transparent. But I can tell you in my personal experience, being in a tribunal, in over 90% of the unfair dismissal cases, including constructive unfair dismissal cases, that eventually go to tribunal, the disciplinary hearing has been predetermined. So what can you do about it? Well, you challenge, and you challenge as hard as you can. You fight. You firstly ask them if this meeting is predetermined. Is it illegal to predetermine a meeting? Well, not always. Is it unfair? Almost certainly, yes. So you ask the question, has this meeting, the outcome of this meeting, been predetermined? They will give you an answer and they will probably say, no, of course not. It's all very open and transparent. It's all very fair. We just want to hear your side of the story. We're going to judge it based on the evidence. We haven't made our mind up at all. But if it has been predetermined, then the allegation should have been put to you in a timely fashion, and you should have had more than enough time to prepare your case, your side of the story, to present to them in the hearing. And you will know when you're presenting your case whether they are interested in your side of the story, whether they go off to investigate anything that you've said or any further evidence that you have perhaps introduced or suggested to them that might be available. You will know there and then pretty much whether it has been prejudged. However, if you need to fight and you need to challenge the process, then this is what you really need to say. I feel this process is predetermined and this process is prejudged. Make them record that in the minutes. You will need to rely on it later on if it goes to tribunal, and it can be very useful for you if it goes to tribunal. Certainly when you come to cross-examine in an unfair dismissal case, you will be able to cross-examine based on that basis, that premise, and get more evidence if you need it. It may also be enough of a jolt for your employer to take a look at things again. Now, if you need our help, if you're heading to tribunal or you're running your own case at tribunal currently, head over to tribunalclaimshub.com for more information.